Good morning, everyone.
Good morning, sir.
Today is the first day of June 2023. Happy New Month, everyone.
Happy New Month, sir.
And we are continuing our lectures on petroleum law. Today we are looking at the problem of gas flaring. Yes, I believe you've all read the article.
Yes, sir.
Good. Now my students are beginning to sit up. Okay, so I will run through what we have here. Then I will take some of your questions. Is that okay?
Yes.
For purpose of the recording, let me still go through the lecture, because next year, students that will teach next year, I may not have so much time for them. This is what they'll go and watch. From next year, I'll be meeting with them once. I won't come Tuesday and Thursday. I'll just come once, because my program is I'm teaching 6 courses now. Can you believe? Grace, can you believe 6? It is so. Okay, so we've already looked at the problem of gas flaring, that petroleum is often associated, when crude oil is being brought to the fore, it is often associated with gas, natural gas. It's not all the time. We have gas wells. We have wells that do not even necessarily have petroleum. We just have natural gas. Most of the wells we have in Bahrain, that Bahrain axis, they are gas wells. Are you with me? But we also have crude oil, wells that have crude oil that we now discover to be associated with petroleum, and in bringing it to the fore, the oil company has to make a decision. What do I do with this gas? I can utilize, but I can commercialize. If there's a market to buy, I can re-inject or I can flare. And I told us that for the most part, flaring appears to be cheaper. Are you with me?
Yes.
Less cumbersome. You just flare, you burn off what you don't necessarily need, and then you take your crude oil, export, and then make your money. But this has certain implications. There's economic implication, because you're wasting a lot of money. You're wasting a resource that can be used to address problems, particularly for Nigeria now, that suffers a lot from acute power shortages, and we need gas to power most of these our plants. So yes, you're wasting a resource, and that has economic implications. And then, more importantly, perhaps, you are damaging the environment. We try to look at some of the implications of gas flaring on the human environment, and we looked at policy and legislative initiatives to curb the problem of gas flaring. We went as far back as the Petroleum Act of 1969, which had mandated companies to submit plans, utilization plans, and which also reserved for the Minister of Petroleum the power, when issuing out upstream concessions, the minister also had the power to take flare gas, at the point of flare without cost to the producer. But that was where it was. Then we came up to AGRA, Associated Gas Reinjection Act of 1979, and we tried to look at the focus of AGRA was reinjection and perhaps utilization, but next to nothing was said about commercialization. And we pointed out that the fines imposed under AGRA were paltry, and they were not sufficient to deter companies from flaring gas. Are you with me so far?
Yes, sir.
And so, despite all the repeated deadlines that have been set, the problem remains acute, not just in Nigeria, but in most of the world. And we looked at policy initiatives. We emphasized the fact that to address the problem of gas flaring, you do not just rely on one strategy. For example, you do not just criminalize it and then impose fines and sanctions, but you explore other measures. First of all, I want to emphasize that there's no way a company will not flare gas. I said that, didn't I?
Yes, sir.
And the same way, there's no way oil will not spill. But we're trying to say, let it be at a very, very acceptable, minimum acceptable level. And so, to address the problem of gas flaring, it has been argued that rather than take a negative approach, we should use a more positive approach. Rather than say, don't flare, let us look at, can we sell? It's rather than say, don't burn this sheet of paper, because we have them piled up. Or look at my office. All these papers are all waste. You understand me? Yes, so you can take an approach, bond them. Look at papers everywhere. Most of them will never use them. You can now look for somebody that can recycle. Is that not so?
Yes, sir.
I don't know if we have recycling companies anymore in this country, but in the UK, they are all over. In fact, you have in every neighborhood, you will see this dustbin. These bins now.
Yes, sir.
Yeah, you see two kind of bins. There's the one for recyclable items, and there's the one for your normal bin. So if I'm going to trash things, and the normal trash, you put them in bag A or box A. Then things like this. Are you with me?
Yes,
Put them in box B, and then a company comes, takes them, recycle them, and then and all that. So the idea in addressing the problem of gas flaring is now, don't just tell the company don't flare, but rather give them incentives to benefit from even the flare. So that is where we were. And so to do that, the government had to or has to develop other mechanisms or initiate other projects to encourage the utilization of our gas. Nigeria is said to be a gas province with a few oil. If that is the case, then how can we ensure that gas gets to everybody? For example, can we power our cars with gas? Timi Prisilva tried to do that, but we could not necessarily see the full manifestation of it. But at least in some form, he tried to push forward for gas utilization. He declared that this decade is the decade of gas, and it was moving forward to cars being powered by gas and not with crude oil. Are you with me?
Yes, sir.
Because crude oil is rapidly declining, and it is foreseen that a time will come when Nigeria will not be with. Most of you in your lifetime, there will not be crude oil in Nigeria. Even in my lifetime, God willing. So most of you are in your 20s. It is believed that at current rate of production, maximum 40 years, max. Because when I was doing my PhD, it was 40 years. And that was 11 years ago. So let's say 30 years, but max 40. There will not be crude oil again. But gas, Nigeria's gas can continue for the next 150 years, 100 years. Are you with me? Yes, that is how rich Nigeria is in gas. So we try to also look at the fact that other initiatives were put in place to develop our gas market and gas infrastructure. We looked at what Olusegun Obasanjo tried to do, Yar'Adua and Goodluck, and then we have now come to Buhari. For Buhari, I told us that the major policy thrust is gas commercialization. Are you with me?
Yes.
The gas that you would have injected or the gas that you would have utilized. We are now saying to you, Oga, don't prioritize reinjection and do not prioritize utilization. Prioritize what? Commercialization. And so in 2016, the Nigerian gas flare commercialization program was launched. And the aim was to end gas flaring by 2020. Of course, that did not happen. And they aimed at eliminating gas flaring through the adoption of technically and commercially sustainable gas utilization projects developed by competent third-party actors. I emphasize that in 2017, the gas policy was launched, and the strategy was that in the absence of compelling technical reasons of a viable outlet for gas, the government intends to restrict undue reinjection of associated gas. Rather, it intends to maximize the utilization of associated gas to be treated for supply to power generation or industry. And then we stopped that day, 2 days ago. We stopped at looking at the legal framework. I told us that a policy is simply a manifesto of government intention. When you have a policy, it means that this is what we want to do. This is the direction that we're going to. And if there's a tendency that policy will be resisted, then most likely the government will back it up with a law. Are you with me?
Yes.
And so the legislature will have to come in to give some legal backing. And that is what has happened here. The legal backing came in the form of the Flare Gas (Prevention of Waste and Pollution Regulations) of 2018. Flare Gas Prevention of Waste and Pollution Regulations of 2018. And then this regulation was made in pursuance to Section 9 of the Petroleum Act, Paragraph 35B, Paragraph 35BI of the first schedule to the Petroleum Act, and the Associated Gas Reinjection Act. So we will try and thank you, Father. We will try and look at some of the provisions of that regulation, and then see what we can get from it. So we are going to run through the provisions of that regulation. But let me just, first of all, before we look at it section by section, let me just run through key provisions. Key provisions: mandatory reporting and access to gas flare data, mandatory access to gas at flare, increased flaring fines, the publication of flaring standards, the imposition of metering requirements, the imposition of reporting obligations, and the prohibition of flaring and venting of gas, of course, except you are permitted. So those are key provisions. So now let's see if we can rush through the flare gas prevention of waste and pollution regulation of 2018. Bless you, my daughter. So regulation 1, first of all, the objectives of this regulation is to reduce the environmental and societal impact of gas flaring, to protect the environment, to prevent waste, and to create social and economic benefits from the capture of flare gas. I'll take it again. To reduce the environmental and societal impact of gas flaring. I'll send you the regulations if you want. Yes, sir. You want?
Yes, sir.
Good. Again, remind me.
Yes, sir.
To protect the environment, to prevent waste, and to create social and economic benefits from flare gas capture. Just before we go further, the problem of gas flaring there had been a judicial aspect. What is it? Are you telling me? How can that be? But is it still working?
Yes, sir.
Okay, good. There had been some attempt to stop gas flaring, and so I would like you to look at the case of BEMRE, G-B-E-M-R-E, BEMRE versus Shell. BEMRE versus Shell and others. This class, people are interested. You don't normally ask me for my slide. That is why I don't give. You don't want it?
No. So you see that once we ask for your slide in first semester, I know that we should go and read our record in our form, our notes. So you're not giving us the slide.
It's not me that said that kind of thing. It's not me, Pero ways to buy. Maybe it's my twin. I always make my slides available. Don't I make it available to company law students? Don't they tell you? Why will I not make it available to you people, my own students?
The last time I remember, you said you were not done.
Except you say I'm not done, but not to say I say I will not give. That is not my nature.
First, we were sending them.
Okay, I was sending initially.
Yes.
Siam, me. Tell me sorry.
Sorry, sir.
It's okay. Can we continue?
Yes, sir.
Good. So I'll send you the slides. I think it will also help you guys. Of course. All my topics, I have slides. Like this is my longest slide. It's 109 slides. It will really help you guys. So BEMRE versus Shell. What happened in that case was that some people in Delta State, I think Orobo people, had taken Shell to the Federal High Court, alleging that the continuous flaring of gas was affecting their right to life. Are you with me? That for them, the right to breathe, they have a right to live, and they have the right to inhale, a good air, live in a good environment. So the continued flaring of associated gas was affecting their right to life. And the Federal High Court gave an order declaring the gas flaring was illegal and gave an order for them to stop. but there was no enforcement. So I just want you to know of that case. Then also Ronto Douglas versus Shell. It's not directly about gas flaring, but it's about EIA when they wanted to launch the LNG project, and Ronto said, yes, it's a good thing you people want to do, but the law says conduct an EIA. Let the Bonny people know what they are into. Are you with me?
Yes, sir.
And they did not, so he rushed to court, and the High Court said that, you don't have a locus. You remember the case? And then we went to Court of Appeal. Court of Appeal said that the High Court admit some mistakes and all that, so take it back to the another High Court to retry it afresh. But by the time they were going to that High Court, the project had already been launched, and so somehow it had been overtaken by events. But those are cases I think you should know about. Is that all right? Yes. So on the AC, on the lights, yeah. So what you need to know about this regulation is that Regulation 12, okay, so Regulation 12 of the regulations also, come on the AC please. It's coming on now, just on it. Regulation 12 also prohibits the flaring of gas. Are you with me?
Yes.
I will just, for purpose of recording, let me just read it out. No producer shall flare gas from any facility operated by such producer except pursuant to a certificate issued by the minister further to the provisions of the Associated Gas Reinjection Act. That act has been repealed by the PIA. No permit holder shall engage in routine flaring or venting of natural gas from any facility operated by such permit holder. No producer shall engage in routine flaring or vent natural gas from any greenfield project. What is venting? So in the course of your reading, you may come across the word gas flaring or gas venting or the venting of natural gas. They are not exactly the same thing. Venting occurs when, please listen, in the course of piping this crude oil or the natural gas, there are some times when the oil company will want to release gas into the air. Yes, please. I have the class. When I'm done, sir. I want to see me. Okay, please come in. Are you with me, my friends?
Yes, sir.
So, venting is that you are releasing the gas. Flaring is that you are burning it. You burn associated gas, but you can flare gas. You can vent gas even if it is not necessarily associated with crude oil. But both of them are prohibited except you have a permit. So no permit holder. Look at Regulation 12, paragraph 2. No permit holder shall engage in routine flaring or venting of natural gas from any facility operated by such permit holder, and no producer shall engage in routine flaring or vent natural gas from any greenfield project. So I just want you to know that. Remember, we're looking at the prohibitions and some of the core projects, core provisions. One other thing that this regulation has done is to confer upon the federal government the right to take flare gas free of cost at the point of flare. If you have read my article, you will have seen what I made mention of it. You remember?
Yes, sir.
That under paragraph 35 of that Petroleum Act, the minister had this right to reserve, had the right in issuing all these upstream concessions to say, we are reserving the right to take flare gas. If you want to burn it, that means you want to waste it and damage our environment, it's of no use to you. I have the right to take that waste without paying you. That's what we are saying. Tarila, are you with me?
Yes.
But this is not a blanket provision, and I argued that in my article. It's not a blanket provision. Rather, if we are going to give a gele a concession, we have to specifically provide for it. And then if we are going to give blessing, we have to specifically provide for it. If there are no such provisions, then the minister does not have an automatic right to say, okay, I'm coming. Because once you give somebody an oil mining lease or an oil mining, prospecting lease or what's the other one now? Yes, yeah, PML and PPL. Once you are giving them those concessions, you are basically giving them a right to that petroleum. Are you with me?
Yes.
You don't have the right to now go and say, that petroleum, I want it. Rather, the government can say, don't burn. But the government cannot say, that thing you want to burn, I am taking it. No. If you must take that gas, you should be ready to pay for it. The only time you can take it without paying for it is if at the point of issuing out the concession, you reserve that right and say, oh, gas, I'm giving you this license. No burn gas. Any gas you want to burn, I can take it without paying you. I hope you are clear.
Yes.
Good. But this regulation is a blanket provision that now says that the federal government has the right to come and take flare gas. And I was saying that the oil companies can challenge it. They can say it's amounting to expropriation, or they could say it's amounting to seizure, expropriation, and a breach of contract. But I've not heard them do anything in that regard. But it's something we still need to know. Can we continue?
Yes.
Good. So if I ask you in the exam hall, what is the basis, what is the justification for the federal government attempting to take gas free of cost at the point of flare, you should know that you should be able to tell me about paragraph 35 of the first schedule to the act. The essence, in summary, what this regulation does, because before we look at the nitty-gritty, in essence is that the federal government is saying that we want to be able to come to your point, to your concession area to take this flare gas, and now we are going to give it to third-party actors, what we may call smaller companies, smaller gas companies, who will be able to employ the adequate technology to capture it, bottle it, and then sell it. So what probably you thought was a waste economically, that was also destroying our environment, we have some other younger persons or upcoming entrepreneurs that can capture that gas and sell it to the Nigerian market. That is the whole gamut of this regulation. Are you with me so far? Yes. So you will see that it provides for permits. First of all, there's the permit to access the flare gas, and then there's the permit to access data. Before you are given the permit to access the flare gas, once you have that permit to access the flare gas, the government is saying to you that if we've given the whole of Igbogene as a concession, let's say PML and Petroleum Mining Lease 20 to Chevron, we are now giving a permit to Tarila to enter into that premises, which again can lead to problem. Is that not so?
Yes.
Yes. To enter into that Igbogene there, at the point of the flare, to capture the gas. Tarila will now bottle it and transport it anywhere he wants to do, and now sell it probably to the market, the retail market, and all that. So Regulation 3 provides for the permit to access flare gas. It is granted by the Minister of Petroleum after a competitive bidding, and it is to be granted to a qualified applicant, and the permit grants him the right to take flare gas on behalf of the federal government at the flare sites as specified in it. So once you are given that permit to access flare gas, it simply means that you are an agent of the federal government, and then you are able to take this gas. Of course, the permit must be granted after a competitive process. Again, I told you that the discretionary approach to petroleum concessions has been done away with. Everything now, you have to compete for it. And so it has to be competitive, it has to be transparent, and it has to be done publicly. Any questions? No question. Just wait. I'll take your question. Let's continue. Regulations 3 3 sub 2 and regulations 3 sub 3. Please note them. I think I should read it. The minister may, by a permit to access flare gas, authorize a qualified applicant selected further to a competitive bidding process conducted by the federal government to take flare gas on behalf of the federal government at any flare site as specified in the permit. As specified in the permit. What we are now saying is that once this permit is granted to a company, if the permit is granted to Tarila, for example, Chevron cannot go back to the federal government and say, Oga, sorry, that flare gas that Tarila was to come and take from our premises, he can't take it again because we want to use it to power our own plants. The moment the permit is granted, even the oil company doesn't have that right anymore. So the federal government is curtailing the right of the company. That does not mean that they do not have a right. Please listen. That does not mean that they do not have a right to still use or commercialize the gas that they would have otherwise flared. The oil companies still have that right, but they can only exercise that right if a permit has not already been granted to a company. Keep it open. What you can do, close the other door. If a permit has already been granted to a company, then Chevron cannot take that flare gas again. Are you with me? Are you with me? Yes, they cannot take that associated gas again. But if a permit has not been granted yet, then they can now go to the federal government and say, please, I want to utilize or I want to commercialize flare gas. You see that in regulations 2, subsection 1, I think again for purpose of recording, I will read. Pursuant to section 9, subsection 1, sorry. Yeah. Okay, sorry, I made a mistake. Regulation 3 sub 2, not 2.1. 3 sub 2. Subject to the provisions of these regulations, please listen. Any producer may apply to the minister to utilize flare gas for commercialization, provided that such application shall exclude any flare gas volume that is being offered in a bid process conducted by the federal government or has been assigned to a permit holder and be made by the producer on behalf of a midstream subsidiary, corporate entity, blah, blah, blah. So what the regulations are saying that is that, please look up, the producer can still use can still make use of flare gas, can still commercialize it or use it to power its plants internally. But in doing that, you have to go back to the minister and ask for permit now. That is a new rule. And secondly, the gas volume you are applying for must not have been something that has already been parceled out to a third-party operator. Yes, so if I've already said that all the oil wells, all the gas that is flared in the Bogene, we are giving it to Tarela, go and take it and commercialize it. Chevron cannot now go to say, Oga, please, I want to use it. Are you with me? Yes, good people. Yes, so regulations 4 and 5, you want to note regulations 4 and 5. First of all is that the DPRO, which is now the Nigerian Upstream Regulatory Commission, may request for what they call flare gas data, FGD, from the producer. So every company that is producing gas now should also be able to have a data of the amount of gas it is flaring. And the government has a right to request for that data, because it is on the basis of that data that we can now say, Tarela, come and pay amount of money so that you can go and capture. I don't know if you understand.
Yes.
if the flare gas is next to nothing, if the company flares next to nothing, then you cannot start talking about flare gas and permit to access flare gas. It is on the basis of that data we can now say, these people have a lot of gas that they are flaring. Oga, are you interested? Or go and take it. I don't know if you understand.
Yeah.
So it starts first of all with a request for flare gas data, which the company must provide to the regulator, and if you fail to do that, there are consequences. So you want to see regulations 4 and then regulations 5. After that, there is a second permit that is given, or they call it data access permit. Regulation 6, data access permit. So anybody now who wants to bid, so if Tarila, for example, wants to bid, Tarila Nigeria Limited, because everything must be done by a company, not an individual. So if Tarila Nigeria Limited wants to bid for the permit to access that flare gas, the first thing it will need is information, because you not bid for something you don't know what are their prospects. Is that also? Are you with me?
Yes, sir.
So the first thing it's going to ask for is, I need to access the data, the information about the extent of gas that is being flared. And so for that, Regulation 6 provides that he can apply for a data access permit. A data access permit for flare gas data. For flare gas data. And once he has that permit, it will allow him, the permit will allow him to be able to also go into the premises of the company. The premises of the company in order to see for himself what they are doing. It is on the strength of that information that he can now prepare his bid and apply for the permit to access. So the permit to access data is the one, and to access flare gas is the one that allows you to take the flare gas. But before you are given that permit to take the flare gas, you will first of all be given a permit to access data. And this permit to access data also authorizes you to enter into the premises of the company in order to also see things for yourself. But of course, you must give the company 7 days notice. You cannot just wake up and say, Oga, let me come and see what you are doing. That is what the law says. So that is what I call a DAP. If you look at my slide 94, I refer to it as a DAP, or data access permit, which must conform with the rules and regulations, and may be revoked under Regulation 7. The DAP may be revoked for failure to comply with the permit conditions or the conditions under which it was granted. And then if the company provides false information to DPRO, which is now NUROC, it may also be revoked on that basis as well. But now let's focus on the main thing, which is the permit to access flare gas data. Regulation 8 deals with it. What does it authorize the company? Regulation 8 authorize the permit to authorize the company to take, dispose, or utilize flare gas at one or more sites on an exclusive basis. To take, to dispose, or to utilize flare gas at one or more sites on an exclusive basis. It must be issued, the permit is issued to a company incorporated in Nigeria, and that company must not be a producer. Please listen. That company must not be a producer. Just like recently now, there's a scholarship I wanted my son to apply for, but the scholarship comes with some conditions. You know, there are these Shell scholarships, Chevron scholarships they used to give. They could say, if you already have Chevron, don't apply for Shell. Some of you have Chevron, you say apply for Shell, which is wrong. Some of you have NNPC and Shell, you say apply for Chevron. That is how you begin to erode your morality. You think God is blessing you, but what you are doing is that you are diminishing your personality. So, because the reason is because they want the scholarship to go round. Is that not so? Yes. So if Tarila has a Chevron, because most of those things are joint ventures, Tarila has Chevron, it should not apply for LNG. But you are happy. When I did school, I get money. I've been get Chevron and Shell and NNPC. If you see me that time, where are you now? You are still broke. Praise the Lord. So my son wanted to. So somebody told me in Kayama, Shell is giving scholarship, blah blah blah. And I know if you apply, you will get it. But there are certain conditions. If you already have this, don't so. And I had that in the same. If you already have. Are you with me? Yes, so there's no need to go. Let the money go round. Let the money go where? Round. So that concept is brought here. If you're already a producer, you already have oil block, then don't come and also apply. Let this one go to other third-party actors that are coming up. I don't know if you understand what I'm saying. Yes. Good people. And I told you before that if the flare gas is not being offered by the federal government, the oil company, if it's a producer, can apply to commercialize or utilize. But in doing so, it cannot also do it directly. It must establish, the producer must establish a midstream subsidiary. It is through that subsidiary it can approach the federal government and say, we want to use this flare gas. I felt I should point that out. So the firm applying must not be a producer, and the permit will specify the term. Is it for 5 years? Is it for 3 years? And all that. Under Regulation 8.5, once you have the permit, it also gives you what they call a right of way. A right of way within the license or the leased area. So if I have a PML and this permit to access flare gas has been given to a gele, I must recognize his right to enter into my premises. Are you with me? Yes. Of course, in doing so, if I'm a company that is very, very security conscious and environmentally conscious, he will have to comply to my standards. Is that not so? Yes. Because if he's coming to my premises and I say everybody entering into this area must put on this kind of boot or this kind of helmet or follow this safety precaution, he has to be ready to comply with them. That one makes sense now. Yes. If not, the whole place can enter into fire and all that. So basically, I want you to know that the permit, can it be revoked? Yes. Everything government gives to you can be revoked. The permit to access flare gas data, I told you, can be revoked if you fail to comply with the conditions or you supply false information and all that. The permit to access the flare gas itself, this one is not data, the flare gas itself is what we are looking at, Regulation 8. Now Regulation 9 is telling us that permit to access the flare gas can also be revoked. Are you with me? Are you with me?
Yes, sir.
You should respond. Encourage me now. Under what instances can it be revoked? Number one, non-compliance with terms and conditions of the permit, dissolution or bankruptcy of the company. So if the company is dissolved or becomes bankrupt, then there's no need to continue. Termination of a bond after 30 days. If the company has gone to has signed a bond, and probably is unable to pay its creditors, after a period of 30 days. Are you with me? Then it could be revoked. I hope you understand this one. Kuro, do you understand it? So explain it. Termination of a bond after 30 days. My son, on the fridge.
Termination of bond after 10 days is a ground for revocation of right of permits.
Mm-hmm.
It means that I don't really have to explain it.
Explain it the way you understand. Don't worry, sit down, my dear. So what we are saying is that a bond is an agreement, a commitment, basically. Marriage is a bond. Is that not so? Yes. So when they say you're in marriage, you're in bondage. Everybody, like me now, I'm in bondage to my wife. My wife is in bondage to me. Marriage is a bond. Yeah, are you with me? Yes. Good people. So now, in order to secure the permit, the company itself that is applying for this may not have so much funds. Are you with me? But it may have gone to a bank to say, Oga, I'm signing a bond with you for you to probably give me money to pursue this project. Are you with me?
Yes.
I will do A and B and C to you. I will pay you this amount of money or whatever condition you want to. So you have entered into a bond. It is on the strength of that bond that you're able to access this permit from the government. If you fail to meet the terms of that bond and it is terminated, you have 30 days to get a second bond. If it terminates after 30 days without your replacing it, then that is a ground for revocation. Can we continue?
Yes, sir.
Another condition is termination of a gas supply agreement. Termination of a gas supply agreement. So let me read it the way it is here. The gas supply agreement to be signed between the federal government and the permit holder is terminated in accordance with its terms. If a gas supply agreement signed between the federal government and the permit holder is terminated, that also becomes a ground for revocation. What is the effect of termination on prior obligations? Remember from first semester, it does not affect your pre-existing obligations. Is that not so?
Yes, sir.
Good. So that same concept is brought here. And look at Regulation 9. When I send it to you also, can you transfer this permit to access flare gas? Yes. Transfer, assign, the same kind of concept. You look at it in first semester. You need to get the permission of the government. Is that not so?
Yes, sir.
Yes, the government must permit, and then the transferee must have minimal technical and financial requirements necessary to be a qualified applicant under a flare gas bid process. So the person you are transferring it to, when I bidded for this permit to access flare gas, I was required to have I was required to meet 1 or 2 or 3 conditions. This person I am transferring it to must also have the same capability. I don't know if you understand. Yes. And secondly, the person must be ready to assume all my obligations. All my obligations. Yes, please.
I have a question on that.
Okay. Keep it in writing. Just keep it when we are done. Is it okay?
Yes, sir.
Let me just run through for purpose of my video. Okay, so I said you can do your transfer, but you must need the permission of the NUROC, which used to be DPRO. The regulation says DPRO, and all that. So please look up Regulation 11. Regulation 11 deals with what they call data prying. Data prying, it has provisions for what they call data prying, data leasing, and all that. A qualified applicant appointed in accordance with these regulations shall pay fees to the federal government as may from time to time be specified by DPRO for data prying, data leasing, and award fee for grant of permit, blah, blah, blah. So this basically has to do with fees that you will have to pay to the federal government and all that. Now let's look at gas flaring again. Let's come back again to gas flaring. Like I told you, one of the things that this regulation has done, I told you that under the AGRA regime, the penalty for gas flaring was very small. 10 cents for every 28 point something SCF, standard cubic feet of gas. 10 cents. Do you remember I told you that?
Yes, sir.
10 cents. And it was felt that that amount of money was extremely too small. And oil companies, having paid that money, still attempted to reclaim it as a tax relief. And so what this new regulation has done, like I showed you from Regulation 12, is to first of all say, don't flare gas unless you have a permission. Don't vent gas unless you have a permission. But if you must, you know that you are ready to pay some fees. Even if we give you this permission to flare gas, you still have to pay somewhat fees. And the fees that you have to pay will be dependent upon whether the producer is a marginal field operator or is a substantial operator who has a complete concession. Are you with me so far? Yes. So let me read what you have. I think they made a mistake because here they only refer to marginal field and oil mining lease, but they ought to have also included oil prospecting license. Yes, so it's not just OML and marginal field. We know that we have the OML, we have the PML, PPL, and then we have the marginal field, and now we also have the frontier basins, yes, and all that. But let me just read what we have here. So penalties for gas flaring. A company that is producing 10,000 barrels per day in an oil mining lease or a marginal field must now pay $2 instead of 10 cents. So you can see the level of increase. $2 for every 28.317 standard cubic meters, or in brackets 1,000 standard cubic feet of gas flared. So for every 1,000 standard cubic feet or 28.317, I think they're equivalent. You know, so we have these measurements, we have British measurements, we have American measurements. I don't know if you understand.
Yes.
We have meters, and then we have Americans use, is it miles? Then the English people use what? Kilometer now.
Yes.
That's why if you see some cars that maybe you have or your uncle or parents may have, when you look at this speedometer dashboard, we have two measurements. No be so? Is that, have you not seen it? Yes, it's in my car as well. So you see miles, the big one could be miles, and the small one will be kilometer. So I think that same concept is brought here. So you pay $2 for every 28.317 standard cubic meters, or for every 1,000 standard cubic feet of gas flared. And this is notwithstanding if it is a routine flaring or a non-routine flaring. However, there is a defense. The company will not be mandated to make this payment if it flared gas as a result of an accident, war, community disturbance, insurrection, storm, STORM, earthquake, or natural phenomenon beyond the reasonable control of the producer. Beyond the reasonable control of the producer. But if the company produces less than 10,000 barrels per day from any OML or PML or marginal field, it is to pay $0.50 or 50 cents for every 28.317 standard cubic meter or 1,000 standard cubic feet of gas that it flares. I hope you are clear. Are there exceptions? Again, yes, the same exceptions I just gave you. The same exceptions. No liability for accident, war, community disturbance, insurrection. So please go back again, listen to the recording, and then you will be able to have a firm grasp of that. No amount payable in respect of an agreed volume of flare gas. Let me read Regulation 13.3, please, just a second. Notwithstanding the provisions of sub-regulation 1 and 2 of this regulation, no flare payment shall become due in respect of an agreed volume of flare gas that the producer is committed to deliver to the permit holder under a deliver or pay agreement entered into with the permit holder as from the commencement of commercial operations by the flare reduction project, except to the extent that the producer does not comply with the requirements of these regulations. Okay, this AC, is it working well?
Yes, it's over.
Really? Under Regulation 14, the minister may revoke a certificate of flare gas if the producer, please listen, commercializes flare gas without regard to Regulation 3 of the regulations, or does not comply with the regulations at all. Is it still working?
Yes, it's still working, but less than 10%.
No problem. So remember that the Minister of Petroleum can give an oil company a permit to flare gas. Regulation 12 says don't flare except you have a permit. That permit comes in form of a certificate. So you can flare, but you pay a small thing. Are you with me? Yes. Because the permit to access flare gas, that program, I don't even think it has even kicked off up till now. Initially, there was some excitement about it, and then some people were bidding, but to my knowledge, it has not kicked off. If it hasn't kicked off, that means companies will still be allowed to flare gas and pay this money. But to do that, they will need a what? Certificate. That certificate is a permit from the government. Are you with me? That certificate itself can be revoked. The minister might say, Oga, that certificate, I'm revoking it. If I now hear that gas you say you want to flare, you are commercializing it. You are commercializing it. Or you are not complying with the provisions of this regulation. Like for example, the regulation says you should have a meter. Every gas you flare, let us see the record. If you fail to comply with all those obligations, or the certificate I gave you, instead of you to be flaring the gas, you are bottling it and commercializing it, then it is a ground for me to say I am revoking it. Yes. Regulation 15 deals with continued obligations. Continued obligations. Obligation to maintain a daily log of the flaring of natural gas produced. Permit holders are also, so differentiate between permit holders and producers. Again, what is the difference? Yes, the difference. Again, yes, permit holders and producers.
So producers, they are the ones giving the concession.
Okay.
While permit holders are
The third party actors.
Actors who are giving permits as well.
Excellent. Thank you. So, both of them have obligations. The permit holder also must not flare gas. He himself must not flare. Regulation 12. He must not vent. And now we are looking at continued obligations. Regulation 15 says, producers are to maintain a daily log of the flaring of natural gas that they produce in association with crude oil, that is associated gas, and submit it to DPRO within 21 days after the end of each month. Permit holders are also to maintain a daily log of each occurrence of gas flaring and venting of natural gas within their facilities, and submit same again to DPRO within how many days? 21 days after every month is over. Are you with me?
Yes.
And all these logs shall be based on retrieved data from metering equipment. You know, one of the problems we've had as a country with respect to our petroleum is that they say there's no meter. I don't know if you heard in the past, they say Nigerian oil is being stolen. So we say Nigeria does not even know how much it is producing. These oil companies are just blinding our eyes. I don't know whether it's true, but those allegations have been there. There's a body called NEITI, Nigerian Extractive Initiative Transparency, something, Nigerian Extractive Industries Transparency Initiative, NEITI. They produce reports regularly. I think we'll talk about it soon. Exam is June. Is July, Shay?
Yes, sir.
First week. I have to rush with you people, though. Even when I'm not around now, I have to be doing audio lectures. I have a lot to cover. You know, so we had the problem with metering. Condon, are you with me? Yes. We don't know what we are producing. What we are used to is the meter. Give us meter. Most of the companies do not have meter. So they can just come and say we produce 30,000 barrels. Meanwhile, they produce 80. And by the time those officials that go there to visit, you put them inside a room with AC. You know, the person who is already going to regulate Shell, he already feels inferior. When you see the Shell staff, you see their office, you see the food they eat. You are a worker, a government worker, they are paying you 300,000. They are paying this man 3 million. There's a sense of inferiority. I don't know if you understand. Then the man now puts you inside presidential hotel, and you have good food, and they could have somebody to arrange prostitutes for them, which happens. His eyes is not already thinking well. So if they say the thing was sabotage, you just sign it sabotage. It's not sabotage. And so we had a problem with metering. That's what we are saying. So to address that problem, one of the things that this regulation is now doing is that every company must have what? Meter. And then give us the data every month. Within 21 days as each month is ending, send the information to the government. Let us see. Regulation 16. Producers are also to maintain daily records of all associated gas that they produce and submit to DPRO. They are to also submit annual reports each year to DPRO, annual reports, which are to include all flare gas data with respect to each flare site in the format required by DPRO, which is now NUROC. Are you with me? Permit holders are also mandated to submit annual reports, and then the regulator, DPRO, and his successor is to prepare and release these annual reports on his website containing the information. I was doing a work for some people recently, and they needed information. Went to DPRO site. DPRO site has been scrapped. The law says you should put it on your website. So then I went to the NUROC that are taking over from DPRO. They have a website. Annual report 0 for a country of this level. And this law came into force 2021. Corporate Affairs Commission does not have annual report. And they are telling companies to submit annual report. I stated it in my book. They have lost the legality to ask people to submit. I went to CAC Abuja. I was doing research for Ted Fund. I need this and this and this and this data. They say, what do you mean? They don't know about. I said, but the law says you should have it. They don't know what I'm saying. But you will change things in Jesus' name.
Amen.
Let's continue. Regulation 22 mandates companies to have metering and or to now have meters and to maintain safety standards. And Regulation 21 contains consequences for failure to maintain logs or to install meters and all that, or from stopping permit holders from having access to the site. Because if the company, Chevron, now say, you have been given this permit, but will not allow you to enter here, there are consequences. And you find that in Regulation 21. And Regulation 22 deals with revocation of the permit holder's license. That license to access flare gas data can also be revocation. Can also be revoked. What are the grounds for revocation? When the permit holder fails to prepare, maintain, or submit the logs or records or reports required in Regulations 15 and 18. If he fails to install and maintain metering equipment in his facilities, or if he supplies inaccurate, if he fails to supply accurate or complete flare gas data, logs, or records, he can also, on that basis, his permit can also be revoked. Now I'll take some of your questions, my dear. Grace wanted to say something.
Yes, I was going to ask, as pertaining to the transferring of permits, assigning or transferring of permits.
Yes, please.
You mentioned something about existing, there's prior obligations that the person to whom the permit is being transferred to is to retain such obligations. So I was thinking maybe if the former permit holder won't first of all clear off these obligations, will they still transfer?
Intelligent question from an intelligent guest. Sit down. First of all, if your permit is being revoked, revocation is without prejudice to pre-existing obligations. That is settled. Is that not settled? Yes, I was already owing Tarila. I had damaged Igeme's land. while I was having this permit. And the government says because I failed to do A, B, C, and D, they have revoked my permit. That revocation is without prejudice to my obligations to them. That is settled. Our question now has to do with when I'm transferring. If I'm transferring my permit from me to my daughter Victoria, and I already had an obligation to Tarila, would the transfer, will the obligations move to this person or not? No, I will still have to bear them. Are you with me? Obligations will only move from me to her if I am merging. That's what they call mergers and acquisitions. Are you with me? So if company A merges with company B, or company A is taken over by company B, then the obligations of the company that has been taken over will move over to the company that takes over. But in this case, if I'm moving my rights to her, that is without prejudice to my obligation to him. He does not know her. He knows me. Except there's an agreement in that regard. I will still have to pay her. Any other question? Yes, let me hear you, Ikeme.
Sir, you made mention that owing, like those who are owing PML, then, like, let me say, the government is allowed to allow external companies or smaller companies to come and flare gas, like take those flare gas and commercialize them. They are given a permit. And in granting PML to those companies, they have exclusive rights.
Yes.
That means if the government is doing that, isn't it like
it's an erosion? That is the argument, and you see that in my article. It is an erosion of their exclusive rights to that premises. But you may say it is not, because even if you are given a lease, the landlord still has a right of inspection from time to time. If you are renting somebody's house, he may reserve a right to inspect, provided he gives you adequate notice. So I leased my house to Mr. Condon for 7 years. I may reserve a right once in every year to go through that premises. What has he done to my fittings? What has his children done to the wall? You want to inspect. That does not erode his exclusivity. But in this case, we could argue that it is an erosion of my exclusive right of possession, because you are now telling a third party. Yes, sir. No, sir. You are now telling a third party, come inside the compound, and if I refuse access, I can be penalized. Not only come inside the compound, come and inspect my facilities. Number 2, come and take gas that I'm flaring. At the point of flare, go and sell. So that can actually lead to problem, because some companies may resist it. I know these are international companies that are very, very powerful.
Sir,
Yes.
sorry, does it not conflict with the provision of the petroleum industry act? The provision of the
Petroleum Industry Act.
Yeah.
That's what we are saying. It does not, because the PIA recognizes. We are coming to the PIA now. The PIA recognizes the legality of this regulation. Are you with me? Yes, it does. Let's continue. Now let's run through the PIA and the environment. PIA, but let me take a galley first.
So you made mention that the producer cannot be the permit holder.
Yes.
So what if the producer now wants to utilize the gas?
Yes, if he wants to utilize, that's what we are saying. Provided that gas he wants to utilize has not been earmarked to be given to Tarela Nigeria Limited. If it has been earmarked, then there's nothing you can do. If it has not been earmarked, you can approach us. Not directly, but through a subsidiary, a midstream subsidiary, and say, we want to use this gas, we want to sell it, we want to do this. We can give you that permission. I don't know that exactly.
So, sir, at that point, will you be given a permit?
Yes, the government will give you a permit.
So you become a producer and a permit holder?
No, in this case, you are not a permit holder. You are given a permit. Yes, you call yourself a permit holder if you want to use that word. Yes. Yeah, but you do it through a midstream operator, midstream third-party midstream subsidiary. Okay, let's run through the PIA and the environment. We just have you have a class by 12?
Yes, sir.
Which class?
Exemptions.
Eh?
Exemption.
Okay, evidence, okay. So let's rush through the PIA and the environment. Number one is that the NURC and the authority, midstream petroleum regulation, midstream and downstream petroleum regulatory authority, are mandated to promote healthy, safe, efficient, and effective conduct of upstream and downstream operations in an environmentally acceptable and sustainable manner. You want to see that in section 6? And to ensure strict implementation of environmental laws. Strict implementation of environmental laws. So you want to see that in section 6, section 7, section 31, section 32. I'm just giving you an overview. The commission is also to have a commissioner for health, safety, and environment, as well as the community. The same goes for the authorities. So the authority is also to have a director with responsibility for health, safety, and environment. Because some people may argue that the PIA is not an environmental law. It does not have a strong focus on the environment and all that. That may be true, but that is also not true. So it's something you can argue either way. Are you with me? Yes, it doesn't deal specifically with oil spill. All that is left for NOSDRA. It doesn't deal specifically with compensation for oil spills like that. Even though you can still argue that it has provisions for oil spill, because I think section 101 or 103 says that a producer who damages any person's property will still have to compensate. But the trust with respect to the environment is not very strong. That does not mean that the PIA does not have provisions relating to environmental protection. That's what we're trying to point out. Now, number one, these regulators are already mandated to promote health and a healthy, safe, efficient, and effective conduct of upstream petroleum in an environmentally acceptable and sustainable manner. Are you with me?
Yes.
And they are to strictly implement environmental laws. They are also to have commissioners or directors that have responsibility for health, safety, and the environment. And the objectives of the Act also include environmental protection. You remember that companies must also submit field development plans. You remember, which among other things must also meet health, safety, and environmental standards, section 79. Then companies are also mandated to have environmental management plans, section 79 again, 2H. Those are all provisions for environment. Is that not so?
Yes,
Section 92 sub 2, a right of way given to a producer must not have adverse impact on the environment. That is an environmental protection provision. I just want you to note that. And then failure to comply with environmental laws is also a ground for revocation of a license, section 96 sub 1. Then there is also a license holder must also have capacity to rehabilitate and manage the environment. And there's also provision for environmental remediation fund. And each license holder is to access his own environmental liability yearly and contribute to the fund. There's also provision for what they call decommissioning and abandonment. We'll look at it if we have time. At the end of the lifespan of your production, decommission and remove all your facilities. That also has some bearing on environmental protection. So if somebody says the PIA is not strong on environment, you can argue that it's not necessarily so. You can argue either for or against. Are you with me?
Yes.
Good. Now let's rush through the PIA and gas flaring. Section 104, it is a finable offense to flare gas or to vent natural gas, except in the case of an emergency or pursuant to an exemption granted by the Commission. And you must do it in compliance with an acceptable safety practice under established regulations. The fines are payable in the same manner and they are to be subjected to the same procedure for the payment of royalties to the government by companies engaged in the production of petroleum. So the way you pay royalties, that is the same way you have to pay the fine for flaring of gas. And the beautiful thing is that under the PIA section 104, the fine you pay for flaring gas is no longer, you cannot recover it under tax. It's not a tax deductible expense. Are you with me? You cannot go to the taxman and say, I paid federal government $50 for flaring gas. Now that I want to pay your tax, please deduct it as part of my expense, operational expenses. That has been abolished. What is the penalty they are to pay? Section 105 says, to pay the penalty you are to pay, you have to go back to the flare gas regulation, the one we just looked at now. Are you with me? So section 105 expressly recognizes the flare gas prevention of waste and pollution regulation. And before producing petroleum, again, the section 105 says you must install a metering equipment that must conform to the specifications prescribed on every facility for which natural gas may be flared, blah, blah, blah. It again is an offense to fail to do so. Are there exemptions? Yes, there are. Section 107. Section 107, gas flaring. You may flare gas if it is necessary for facility startup or for strategic operational reasons, including testing. What is strategic operational reasons? That is left for the technical people to say. But under section 107, it is still allowed. Every company producing natural gas is also mandated within 12 months of the effective date to submit a natural gas flare elimination and monetization plan to the commission. So the law still mandates companies, Oga, give us a plan on how you want to eliminate flare gas or how you want to monetize it. Are you with me? And lastly, the fines that these companies are to pay, for flaring gas, it is to be given to the community where they operate in, I think that should be section, I will give you the section later. I'm coming. Yeah, I think I just saw it. Community directly affected. Okay, so basically, I think that is that. If there are no questions, we will adjourn and then we will meet again next week. Next week I may not come to Bayelsa, but even if I don't come, we'll have 2 lectures. Are you with me?
Yes.
Online lectures if I don't come. Thank you. I love you all.
Thank you.
Yes.